Mr Chairman, I'm happy to address some issues around 12 and 13-year-olds, but just before I do, I think it's important that we get a bit of a wider spake on this part of the bill and what it means, Mr Chairman. So I just wanted to give a bit of a better understanding of where this is coming from. So we're talking about a sort of a whole Fresh Start package of initiatives for the youth court. It's about giving them that sort of toolbox of tools that they can then dish out to individual young people to see the different needs that they have. It's about extending those court orders. It's also about the follow-up that goes with that, which I think is what's probably most important and certainly from our perspective most exciting about this bill. So it starts with community youth programs really, and there's going to be 1,000 more of them. 700 of them are going to be done via the police, 300 of them are going to be administered by Child, Youth and Family through other actual programs. So the police themselves are going to directly actually work with providers. They're going to see what works in their areas. They know these people. Before it actually gets to court, they're going to do that. So we're talking 1,000 new programs going there. They're places for those lower level youth offenders that are yet to become before the courts. Then what we've got is the court supervised programs and the court supervised camps that are going to be. So actually what a judge can do is sit there and say, actually this is not the first time this young person's been before me, we need to do something different. What they need is an extended court sentence. What happens at the moment is that we see actually a number of them that commit some pretty serious crimes, I want to say as well. We're talking arson, we're talking repeat burglaries, we're talking rape in some instances, we're talking some pretty heinous aggravated robberies, some pretty awful stuff. So at the moment what can happen is a young person can go into, actually the part talks about a whole lot more than just 12 and 13-year-olds, and I'm happy to get to that shortly. So actually what happens is with those young people at the moment is they go into a youth justice facility. It can sometimes take 6 to 8 weeks for them to actually get to the youth court. By the time they do get there, they get sentenced for 3 months. They get back to the youth court, go back to the youth justice facility. They only do another 3 or 4 weeks, and in that time there's no time for the rehabilitation. There's no time to be really turning that behaviour around. Then what this bill is going to do is, first of all, it's going to extend that and it's going to give longer periods of time. Then it's going to attach real mentoring programs. A judge might also turn around and say actually what they need is parenting orders. So many of these young parents are actually parents themselves at that stage or about to become them. And I think it's important that we address that, so we're breaking some of that intergenerational stuff. What it can also do is drug and alcohol orders, and certainly in the second reading of this bill we heard some angst from the opposition about drug and alcohol rehabilitation and what that actually looks like. The department's been working very hard over the last year with those sorts of providers that work in the drug and alcohol rehabilitation. I can say they are very excited about the extra resources that are going to go into that, the opportunity for them to work with young people and make a real sustained long-term difference. So we're also, though, another part of this bill that's not talked about much and a part of the whole package is the Innovation Fund. So we're talking $1.4 million that's going to be back into those communities and going to be offering a fund that actually addresses some of the things that can actually turn this behaviour around and see them. Because I know the opposition are concerned about how these young people actually get to a place of actually committing these crimes, and I'd like to say that we are too. So it's about taking it back, getting some of those orders right, getting some of those interventions right. And what we're also looking at, as they quite rightly said, is we're looking at, we've heard one young man is actually being bandied around in this house already, so we've already been hearing things about Bailey Jr. Kuareki. He started offending when he was 7 years old, unfortunately, I'm going to tell the House. He was well known to police at a 10 and 11-year-old. So there we talk about early interventions and what we can do there. I've just outlined quite a number of them for you that we're doing that you criticised me, actually the opposition did, for mentioning those sorts of interventions. So let's try and get in early. But by the time we get to 12 and 13-year-olds, what we're talking about is those that are committing very, very serious crimes. This bill will address 40 of those worst, is what is estimating, and the police have asked for it. So the police are turning around and saying, these are not kids that have gone a bit off the rails. These are actually young people who are committing very, very serious crimes and leaving a number of victims behind them. They are offences like serious assault, burglary, arson, armed robbery, rape and attempted murder, unfortunately. We're not talking one-offs, Mr Chairman.
Honourable Paula Benn.
We are talking determined repeat offenders who are getting more and more aggressive, unfortunately, as they move through. And these are hardened young offenders that we simply cannot continue to turn our back on. They've been before the family courts. It hasn't been making a difference. The youth court is more experienced at dealing with high-end, serious young offenders. They have more tools. They have greater powers. Our youth court is a world-leading specialist jurisdiction designed specifically to deal with young offenders. And quite frankly, it is going to take a radical approach to turn around those that really are. As I've already stated, the police support this move. They say, and now I do also want to recognise that what can happen is the youth court can turn around and say, actually, there's a number of care and protection issues with this particular young person and send them back to the family court. And that's certainly what we want to see. And I certainly have huge faith in youth court judges that they're going to be doing what is right for those young people, and I think that's what's most important. So the youth court actually does require accountability, and that's what the small, hardened group of very young offenders actually needs. So we hear much criticism of some of that current system and how we're working with those that need it most. We will be holding them to account for, as I've stated, very, very serious offences. It is one part of this bill, and it's certainly one that we unfortunately have had to introduce because of that hard end of those young offenders.
Honourable Annette King.
Mr Chair, this part of the bill is probably the most significant and one which we wish to be able to raise quite a number of points. The Minister in her contribution said that this bill is some more tools to put in the toolbox that could be used by officials, by judges, by police and so on. But I have to say to the Minister, would you put into a toolbox to fix a car an egg beater? Wouldn't you put in the toolbox of tools something you know that works on the vehicle that you have got in front of you? And unfortunately, the Minister's bill does not address the real issues. The first point I want to make is, and the question I'd like the Minister to answer is, what evidence did she base her changes on? What evidence did she receive before she wrote this bill? Did she base her? What evidence did she base it on? Because we didn't hear before the Select Committee any compelling evidence as to why you would make these changes for children and young people in New Zealand. Quite the contrary, Minister. We had some of the best brains in New Zealand, the best experts in New Zealand, appearing before the committee saying the Minister cannot back up this bill with evidence to show that it will work. To the contrary. In fact, many of the things she's proposing don't work. And I think it was interesting to read today, released from Kim Workman. When the National Party agree with him, they love him. When they don't agree with him, they rubbish him. But I thought the statement he put out today was very, very appropriate because we're debating this bill tonight. He said the Ministry of Social Development research into the effectiveness of youth court supervision orders confirms what we have always known: they are not effective at reducing reoffending. Around 80% of serious young offenders reoffend within a follow-up period. Overseas research has confirmed this time and again. There are three things that don't work for young people. They're not cost effective, they are boot camps, scared straight programs and intensive supervision. Went on to say when supervision is over, young offenders return to their previous levels of criminal activity. The deterrent effect of supervision wears off when they're no longer under supervision. In addition, if there are multiple conditions added to the supervision order, young offenders become defiant and find other ways of avoiding detection. And this I thought was very interesting and ties into what Leanne Dalzell has just said, and I thought made a very excellent contribution. What they found, research in New Zealand has found, that the older the offender when placed on supervision, the less likely they are to reoffend.